Vargas Salvador. All right. Esteban.
Judge Esteban, we are comfortable signing the PPO. I have gone over my. I just would note that there is a child on the protection order. I do not see any reference to the child. Oh no, sorry, there is a reference to the child.
So I would not take the child off. Is he going to execute it?
Yes, Judge, he is executed.
Sí, va a firmar la orden de protección temporal, tiene que firmar aquí y aquí, señor.
Esteban, Judge. As to the domestic violence charge, this is has a delay of over 1 year. Last June 21st, 2025. The Sears motion will be filed on that case. Judge, I do have a phone number for Mr. Vargas. He works construction. He's going there for the past year and a half.
Lleva trabajando en este último año y medio.
He really likes it, wants to keep this job.
Me gustaría seguir manteniendo su empleo.
He has 2 children.
Tiene 2 hijos.
He only has 1 failure to appear on these court habeas bonds. I would note that he didn't have an attorney on those cases. He does have an attorney now, however, it was staying in good contact. We would ask for an SOR on these cases to allow for us to work the case and put Mr. Vargas in a better situation.
From the state.
Your Honor, almost all of these charges
Casi todos estos cargos
involve alcohol use in some way.
están relacionados con la ingesta de alcohol de alguna manera.
So I would be asking for no alcohol
Le pediría que le prohibiese la ingesta de alcohol
and TAD as a condition of bond.
y el monitor de detección de alcohol en el tobillo como condiciones de su fianza.
Outside of the new driving, everything else is from 2025.
Todo lo que tiene desde el año 2025.
The 2025 cases will be awarded
Van a ser bajo palabra.
with the TPO being executed. The 26 driving will be OR plus TAD.
Va a ser
You know, alcohol is a condition of
bajo palabra, monitor de detección de alcohol, nada de tomar alcohol, ¿ok? Así. Nada más que salga aquí en el abogado.
Frizell.
Your Honor, Michael has a lot of Mr. Frizzle. I'm already appointed on the case. I believe this is set today to see if he qualifies for the mental health docket.
And did we get an answer to that?
The city does not have an answer.
You should have gave us something. Report to somebody. Alright, let's recall, we're gonna try to reach out to Abigail. I don't have anything as of right now, so
Yes,
I didn't know if she reached out to either the state or the defense. So,
I've not heard.
all right, Shanice is gonna check.
Thank you.
All right. Brown,
It's a walk-in. Broderick Brown.
He's currently running on this one, and it looks like he was cited for this one. That's what we can see in our system. Okay. That's why the case numbers are different. Okay.
Please not guilty. Mr. Brown was cited in court. He's here. He has only one pending charge, no other record. The factual allegations are identical to this complaint, so I don't know what we're doing here today.
Is there anything from the state?
Asking for a no contact order for the victim.
That's fine.
OR plus stay away, no contact. All right. City domestic violence docket. Damian Jones.
Donna Marie Thomas here.
Yes.
There's a request for protection.
Good morning, ma'am. Do you have your ID? Do you have anything with your name and picture on it? All right. If you would show it to the deputy, please.
Not guilty on behalf of Mr. Jones.
Do you have a?
Donna Thomas.
All right. Ms. Thomas, what would you like to say?
I just want to say I never wanted to press charges.
Come over to the box a little bit more. Okay.
I never wanted to press charges. I told the police officer that they did it on their own. I wanted this dismissed. I never wanted him to jail. I'm not scared of him, never wanted to be on.
Allegation is a push. I'm sorry, it's slap.
I was gonna say, I saw a
Sorry,
slap
and push.
and. All right. Ma'am, do you want a stay away order?
No,
Are you concerned for your safety or the safety of any children?
no, I'm not.
Did he turn himself in?
He did.
All right. Is there anything from the state?
Just the allegations here are that the victim told the police that the suspect was a live-in boyfriend, got upset, slapped her in the face and pushed her on the ground, causing physical harm. The defendant does have a felony gun charge. Other dismissals, domestic violence.
Who called the police?
Her sister.
And do the parties have somewhere to stay separate?
Yep, Mr. Jones is staying with his mom.
Because there are 11 failures to appear, I typically would never give an OR bond on that. The only reason, why you look surprised? You ain't show up 11 times. You think I'm about to give you another OR bond?
It's a lot of traffic. I looked at the actual CRVs for sure.
All right. But I am this time because he turned himself in. So, Mr. Jones, you need to make sure that you stay in touch with your attorney. Based on what the prosecuting witness said, it will be a supervised OR, but I am ordering as a condition of bond, a stay away, no contact. So if you all go around each other, your bond can be revoked. And a cash bond or a bond with some other stipulations can be put in place. But this is the second charge this year. So until this case is resolved, you all need to stay away from each other. All right? Supervised OR. Mathis,
That's the law.
there is a parole holder on that list.
There is a request for protection order, Judge Ashley Smith. Ashley Smith present.
Esteban,
Esteban, Mr. Mathis has an APA holder. This deputy, so he has a pending assault charge with the same prosecuting witness. I got that charge as an interview case because he was OR'd. She came to Rumay and said that she was drunk and started a fight. It's the exact same allegations, almost word for word, from a few months ago. She's not here today, but Mr. Mathis has a parole holder as a result. So we just asked her not to move on.
from the state.
Judge, the allegations here are that the defendant knowingly caused physical harm to his girlfriend, who he resides with, by punching her in the face multiple times during an altercation, causing her to have visible injuries. He has a pending charge of assault from July. And I'd ask that he sign the petition.
He's not going to sign the protection order. He will be in on an APA holder, and he turned himself into his parole officer on this particular charge. We'll be in contact, taking care of it.
$5,000 secure plus stay away plus no contact. McLeod.
Judge, there's a request for a protection order. Is Renaya Jones here? Renaya Jones.
Mr. McLeod is executing his EPO. I've represented Mr. McLeod before, not on these underlying PV charges, but on a probation violation, and I'll continue the representation here. It's from a long time ago. I believe it was early November of 2025. These charges are almost 3 weeks old. The allegation is that Mr. McLeod returned the property after some time. And there, this is the one that's exclusively pushed. So Mr. McLeod pushed Ms. Jones into a wall, causing pain and marks. This is a self-defense claim. There's another witness. He's a mutual friend. This will be easily taken care of. There haven't been any other allegations of additional issues over the course of the last 3 weeks. The parties do not live together. Mr. McLeod has his own place now. He has secured rent for 6 months at that particular location. This is the first time in a while that he's had some secured housing outside of the assistance of other parties, and is excited about it. He works for Labor Works. His current position is at Bearda Energy Provision. His mom and dad, I have contact information for. He has older brothers. He says that his older brother is scarier than police, so we'll make sure that he comes to court and can help pay a low bond in this case. The allegation for the probation violation is simple. First of all, his last bond on that was no bond. Allegation is that he needs to complete some mental health treatment, and he and I can work on that together. Again, this is an allegation of a push. He signed the temporary protection order, and he has SOR bond, which is appropriate given the circumstances and the contact information I have.
From the state.
Judge, the allegations here that Mr. McLeod pushed the victim into a wall inside the apartment they share together. And then Mr. McLeod charged after her to assault her, but was held back by her friends. She complained of pain in her wrist and had a visible injury.
You'll note the date, 3 weeks ago was move out date. Do not share a residence.
There are 2 misdemeanors, one of which involved the same PW that was amended now. And 1 failure to appear. The bond is OREMD plus jurors if requested. Did he execute the TPO?
He did.
And the EMD is open hours. All right. Felony lockup docket. Shauna Barnett.
Good morning again, Your Honor.
Good morning.
Barnett.
Kamal Cutman for Ms. Barnett. Wait, probable cause.
Esteban.
Esteban, Your Honor, Ms. Barnett has quite a few unresolved matters in Judge Bender's court. It looks like she has quite a bit on her case. But I think she also has court later this morning across the street. We're asking for an SOR, a reasonable bond in this case, being that she's not going anywhere and she's going to be going across the street to resolve a lot of these matters.
Are these related to those?
They appear to be related, Your Honor. As I read through them, they seem to be multiple events all at the same location.
From the state.
Your Honor, I would be asking for a stay away from Kroger. I would also be asking for a monetary bond just based on previous history.
The court would consider an alternate OR plus interview on this one. Given that she has a lot of, it's pretty high. When you aggregate all the other case bonds together, it's pretty high.
There's 1 violent felony, 3 felonies, 5 misdemeanors, 5 prior failures to appear, 9 pending charges, 5 of which are thefts. $2,500 anyway, plus EMD with a stay away from Kroger.
Grand jury report amount will be 27.
Davis,
David?
good morning. How are you? Good morning, yourself. Good morning, Mr. Davis.
Your Honor, we would waive probable cause and to plead not guilty.
All right. Ask the bond.
As to bond, Mr. Davis is 54 years old. This all happened allegedly on June 10th of 2026. It's not like this warrant has been out since then. They didn't file a warrant until very recently. He has lived in the same home for the past 3 years. He's the father of 2 grown children, and he has a grandson who's 10 years old. The 10-year-old grandson's father isn't in the picture, so Sean takes care of the grandson every weekend to give him that father figure. He has lived in Ohio for the past 16 years. He has 2 jobs. He works at Avondale TCB, Community Builders as a maintenance tech, and he works on the side painting houses for UC students in Clifton. He previously had a job, he always works. He previously, before this Avondale job, had a job in Westchester doing similar type work. Your Honor, I would note that Mr. Davis lives in a home with other people. Someone had a concern because he had a lot going on in his life. He relapsed, he overdosed, they called 911. They allegedly found some drugs in the house, and this is why he was charged. So he had to go to the hospital, and then they charged him for saving his life. Your Honor, we are asking for an OR bond or $1,000 at 10%.
From the state.
Your Honor, I would be asking for a monetary bond in this case. The defendant is charged with F3 trafficking and cocaine. He does have prior trafficking convictions, as well as possession convictions. So I believe a monetary bond is appropriate.
I would just note that the trafficking is back from 2005. So I would ask you to take into account how long ago that was as well. He is clean now. He's worked really hard since June to get back sobriety.
Is he in treatment right now?
He is not in treatment. He's maintaining it. He had done treatment for a long time previously. He is maintaining his sobriety through working and taking care of his kid. It was just a relapse that was very short and unfortunately almost had a deadly ending, which happens a lot when people relapse, unfortunately. He was letting someone who's there to call it.
1,000 anyway, plus defendant is to engage in treatment as a condition of bond. Edwards,
Grand jury report amount is 827.
827. What name did you just?
Edward.
Sorry. Things are. Oh, Your Honor, we would waive probable cause and to plead not guilty, please. Esteban, this is allegedly from June 11th of 2026. At the time, Mr. Edwards was actually on EMU lockdown due to having marijuana from Indiana. It was EMU from Indiana, so we're gonna be able to show that he wasn't even, he wasn't even charged with this for months. And he actually, when he figured out he was charged, he showed up to turn himself in because he had no idea what this was from. The marijuana case in Indiana went away. His last felony is from 2019. He's really turned himself, he was 18 years old and he used to get in trouble. He's really turned his life around. He was actually working with Fresh Start Clinic when he found out he had a driving habeas. So he was trying to get his record clean, do the right thing. And then they put these charges on him. He's 28 years old, been in the same home for 4 years, same job, doing tree work for 2 years. He has 2 kids, ages 1 and 2, whom he lives with. We're just asking for supervised OR or 1,000 at 10% or something that he can make. Like I said, this is from 2-3 months ago. It's not that he turned himself in. He's not flight risk. He was on EMU at the time, so it shouldn't have been himself.
We'll also be taking care of the traffic.
Sorry.
All right. On the traffic,
We did the A, drop the B.
That's right, Your Honor.
I'm sorry, it'll be what?
We did the A, drop the B.
What level is the
Is it
A?
unclassified?
Mr. Edwards, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to driving under FRA suspension?
Yes, ma'am.
Counselor, do you waive a stipulate? Finding of guilty, mitigation.
In mitigation, it sounds like Mr. Edwards has his life together. I was looking forward to closing out some older aspects of his life and didn't come forward. There was no FRA with correction.
Anything from the state?
We'll defer on the traffic.
One, credit one, remit the fines and costs. Did you independently verify the EMD lockdown and that there were no violations?
Your Honor, no, I got the case 30 minutes ago. So that is based on what my client said. But I am able, obviously, to look at the complaint and see this happened on 6/10, was charged on 8/14, and that he turned himself into the station.
From the state?
Your Honor, these allegations do involve firing a firearm over a roadway. The defendant is under disability due to a prior trafficking and fentanyl conviction from 2019. He also has prior felony convictions involving firearms. So I would ask for a high bond in this case.
So there is 1 violent felony, 6 felonies, 2 misdemeanors, 14 prior failures to appear. I am willing to recall this toward the end of the docket because if I can be shown any type of court records from Indiana that he was truly on lockdown EMD and that there were no violations, that is going to be very different than a bond I will set right now.
And Your Honor, I would note that most of his history is traffic, which is why there's such a high failure to appear. I'm not sure how I could do something.
The traffic argument does not really work with me because if you don't show up when you can't go to jail, it follows, at least for me, that you don't show up when you can go. So,
He
all right.
says that he was shot in the head and unable to come to court for multiple weeks, but it was traffic. And like I said, he turned himself in. But, I mean, I'll attempt to reach out. I have no idea how.
Showing
10,000 secured plus EMD.
Your Honor, I could state that in Leeds, it does show that he did have a pending charge in Indiana at that time.
Yeah, I see that it was pending and that it ended up being dismissed. I just don't have the date. And that date matters. If he was sitting at home on his couch on EMD, then we're there.
If I'm able to find anything out for the end of the docket, would you rehear it
Recall,
tomorrow?
yep.
Okay, thank you.
Grand jury report on that will be 8/27.
Do you want to just, do you want to put it on for tomorrow
We
and
might be
see
able to call.
if you can find something between today and tomorrow?
Do you mind, Your Honor?
Frederick, these days they might bring it back out, but.
Still put the, okay. We'll call for Zale right after this. I'm sorry, this is Mr. Frederick.
It is, Your Honor.
Waive probable cause.
Your Honor, this time, yes, we would waive probable cause. Your Honor, we do both have some concerns for competency, and Mr. Frederick did mention that he's feeling a bit suicidal now. The allegations in the felony of the third degree, it just states by force, took a cell phone, he states someone was threatening him. He does have an extensive history of mental illness. He's been to Summit in the past based on what he said. He'd like to be able to get an OR bond now and go to PES. I was told by the deputies that they would actually take him to PES. They don't know if they'll hold him or anything, but if he were to get out, they would take him to PES. Otherwise, I'd ask for the jail to place him on suicide watch to make sure he's safe.
These KPS bonds with other containers, they're minors.
And they were set by magistrate. Those are, the minor misdemeanors are OR from the state as to the robbery.
Your Honor, the allegations in this case are that the victim grabbed the victim's phone out of her hand forcefully. They are not known to each other. This happened on the street. I would be asking for a monetary bond as well to stay away from the prosecuting witness.
There's 1 violent felony, 2 felonies, 14 violent misdemeanors, 19 misdemeanors, 5 prior failures to appear. Does it say what the allegation of the force was?
Just force, like grabbing, is what the complaint says.
Your Honor, I don't have anything more in the report that says anything other than grabbing it from her hand.
Mr. Frederick's also been Andy's client in the past, and I'll let him know that Mr. Frederick's has his.
$5,000 anyway.
Thank you, Your Honor. Could you also, does she need to order that you take them to sign it? Okay, thank you.
My concern is PES is not going to keep him. And so that is why I'm setting a bond that, based on the record and the failures to appear, is actually much lower than I would set on a robbery. But based on what the allegations are, I am setting the bond based on what it is likely to come back from grand jury as, and with the record and the failures to appear. I will note on here that defendant alleged was suicide.
Thank you, officer. Thank you.
Your report on that will be 8/27.
We're gonna recall for Zale.
Judge, I believe Mike Lancelot had to go across the street to the courthouse. I can text him and let you know, to let him know that you're ready.
Do you need to say over, or can we just bring this back? I have to take it. Okay, all right. Okay, can we try to,
I will reach out to him.
thank you. Gerton,
Gertz.
On this one, I'd like to read him, Your Honor.
good morning, Mr. Gerton. All right,
On or about June 13th, 2026, in Hamilton County, state of Ohio, the defendant in this case sent messages as well as called the prosecuting witness threatening to shoot her in the face and kill her. She did have proof of these messages and recordings that she has shown to officers. She also stated that the defendant damaged her car and refused to fix it. However, I will note, I do not see a local conviction for telecommunications harassment. So this is likely a misdemeanor, not a felony charge, from what I can see.
And Your Honor, likely did not happen, given that my client has been detained in the Justice Center since May 19. And the complaint states that this happened on June 13, and even lists a specific address of 6118 Vine Street. My client also does not know this, that any Shayla Jones. And if he actually did these from the Justice Center, I'm sure that there would be recordings that would be provided, or some sort of statement from the corrections officers.
from the state.
Your Honor, at this point, I don't have enough information. However, I will note that may be a defense at trial, but not necessarily a defense for probable cause. If he was incarcerated, inmates do have the ability to text and call people on the outside, so I'm not sure if that is where these are coming from, but that's the information that I have at the moment.
I think there's also property damage listed in the complaint too. You know. I have verified by looking on the Justice Center's website that he has indeed been in detention since May 19th.
He's been in since May 19th. And there's an Indiana holder, so are you just at this point asking for a nominal bond so he gets credit?
Yes, Your Honor.
$1,000 anyway. All right, and I have a warrant, I'll be right back. Court is in
Judge.
recess.
Judge, whenever you're back, Mike is returned, so we're ready to present.
Awesome, okay.
Thank you.
Ariana will be 8:27.
Speak for a second.
See you time out.
Available to go to mental health. Jace, where does your son go to school?
Oh, what's going on?
Okay.
Yeah, we live out in Union Township over on the east side, so
Okay, so you're a little bit further out there.
it's really not that bad. It's still only a 20-minute drive. It's
Oh,
really
that's-
like right off 275.
I guess that's true, because
Yeah,
you
we're
don't
right
have
on
to
the
go.
edge of Anderson Township, so yeah.
So it's not too bad.
Yeah, it's an easy drive, especially for when I come in here. I leave at 3:30 in the morning, you know, there's no traffic.
I can barely get up at 6:20.
For the poison ivy, they've got me on steroids for it. It's driving me crazy. It's giving me worse insomnia. So I'm like not sleeping anyway. I've been on struggle the last few days. Like I'm only getting like 4 or 5 hours of sleep at best, but I'm like,
How'd you get poison ivy?
I was working at our lodge doing some cleanup on some bushes. And I got into it. I never even saw it. I didn't cut it. I was just bagging it up and throwing it in. So I wasn't paying any attention. And it chewed me up. I got it all over right here. I got a bad one here. This is starting to clear up already. It's all over my shins. It's all over like my sides. It's
I'm not allergic to poison ivy. Or so, yeah, it's like my siblings get covered in it.
yeah. That is like if there was something I could be immune to.
Court is back in session. All right, Frazell. All right, good morning, Mr. Frazell. So it looks like Mr. Frazell does qualify for the mental health court docket, and I would go on and transfer the case over to Judge Bender.
Your Honor, I also have a bond motion pending. He does have a place to go at this time. He is very anxious to be involved with the mental health docket. He's been held for 31 days at this time, I believe. I would ask that his bond be reduced to a supervised arrest.
Because if you recall, this was a gesture at a police officer who showed up at the sentencing date. Happy to have him get mental health treatment, but was very concerned at the time. I think perhaps it'd be better for Judge Bender to deal with the problem.
So at this time, I am not modifying the bond. What I will do is see if Judge Bender has availability on her docket, and then her bailiff can get in touch with the state and you to see prior to the next court date if she will hear that motion.
Yes.
All right?
Thank you.
King,
King. Set up the next attorney. Go with him to
waive probable cause
Yes, Your Honor.
as to bond.
Your Honor, as to bond, Mr. King has a very nominal record. I only see one nonviolent misdemeanor conviction for him. He's got no failures to appear and an OR score of 1. He is a full-time student at Empire Beauty School. Your Honor, I would just note that as to the robbery, the allegations are that he tried to take a taser from the officer. It was not a firearm, at least to my understanding, it was a taser. Obviously, this is a high-level offense. I think it's certainly an unusual aggravated robbery. Mr. King is a full-time student, as I stated. He does not have money for bond at this time, Your Honor. He does, however, have supportive family. They would be able to come up with some money to post a bond for him. We are asking the court, just due to his complete lack of record and lack of failures to appear, to consider $5,000 at 10% bond for him. He would be able also to comply with any non-monetary conditions of bond that the court were to impose.
From the state,
Your Honor, the allegations in this case are that the defendant threatened a store clerk, threatening to kill her when officers arrived. He then resisted arrest, and while doing so, told the officer and tried to get his taser. He told the officer, "I'm going to make you kill me. I'm going to take your gun," and then tried to take the taser from the officer. I would be asking for a monetary bond in this case.
on the ag menacing and the resisting, 5,000 anyway. On the ag robbery, 25,000 secured plus EMD lockdown. If he makes the bond. More,
There's a high bond request.
Grand jury on that will be 8/27.
more,
Darren, nine. I'm sorry, Your Honor.
waive probable cause
We do.
as to bond.
As to bond, Your Honor, my client's 25 years old. He's got 2 children, or score of 1, no failures appear in the last 5 years. He went to Doane High School, currently works at LSI in Blue Ash. He tells me that this was an automobile that he had rented out. It was not his automobile. Initially, he was pulled over for a 12-point suspension. It wasn't him because it was attached to the driver or the owner of the automobile. He tells me he can likely make a bond of a few $100s, $300 to $400. We're asking for the court to take that into consideration. There were no drugs found in the automobile. He did not know about this gun that was in the car, Your Honor. And I think there was a recent First District Court of Appeals case that indicated that you have to have a little bit more than just a gun in a car.
From the state,
Your Honor, the defendant was found driving a car where a loaded firearm was under the seat, the driver's seat. He is under disability for an aggravated possession charge and conviction from 2025. These do involve firearm allegations, Your Honor, so I would be asking for a monetary bond as well as no firearms as a condition of bond.
what's the First District case that you're referring to?
I would like to be able to tell you exactly the name of it. I just
What's
remember
the
reading.
premise of it?
Basically, there's got to be more actual and or constructive possession. To show it, you have to show a little bit more than just that a person was in an automobile and there was a gun found in the automobile.
Is that with multiple people in the vehicle or with the individual person?
I just saw the catchphrase on it and I skimmed through it. And it was sometime in the last 2 months, I believe. So I apologize for not having more information, but I still think there has to be some knowledge of it being an automobile and it's not his car, Your Honor, is my understanding. He just wants to be able to keep his job.
Do you have the, jacket?
Yeah.
Is the ticket in there?
The traffic ticket?
Who's the car registered to? Let me see.
Just checking, Your Honor, to see if I perhaps credit that thing from Chris Jones off. Maybe give me the case. And I have one of the appellate sheets in here, but not that one.
If it has the plate, I can go down it for you, but. Give me just 1 second.
All right, we're gonna recall this. Parker, she's gonna run it to see who the car is registered to, and then if you have the case, I want the first district.
He's gonna be recalled. Parker. Full attention to the judge.
Waive probable cause,
Yes, Your Honor.
ask the bond.
Your Honor, as to bond, Mr. Parker is adamantly denying these allegations. He tells me that the prosecuting witness is a friend who was living with him during a tough time. If there was any cell phone involved here, it was a phone that he was just letting that person use. And I would like the court to know that Mr. Parker tells me that these allegations came about after he called that person's probation officer to report their drug use so they could get some help. As to Mr. Parker's record, he does have one felony back in 2021. Other than that, we've got to go back about 10 years to 2016 to get to any of his felony convictions. He tells me that he turned himself in at District 1 yesterday. He is also working full-time at Prus, is that how you say it? Prus Construction as a concrete finisher. That is a very good job for him, and he is very concerned about keeping his job, Your Honor. This is obviously a low-level nonviolent felony. He has no issues in staying away from the owner of the cell phone in this case. We would ask the court for an dollar bond.
From the state,
Your Honor, on the theft, I would be asking for a stay away from the prosecuting witness. I believe we've come to a resolution on the traffic matters.
OR plus stay away on the theft, on the traffic.
There are 2 tickets. One's an A through C. We're going to be pleading no contest to that 21077 A through C in exchange for dismissing the other A through students.
That's correct.
So the 26 is being dismissed, 25, I'm sorry, the 21077, that 26 is no contest to all counts.
That's right.
And dismissing 21252. All right, Mr. Parker, a no contest plea is not an admission of guilt, but it is an admission of the facts alleged against you in the complaint or ticket. The unsafe vehicle, is that a minor?
Yes, everything, and then.
It was a dump truck.
One second.
She's asking about the one charge.
All right, the reasonable control and unsafe vehicle are minor misdemeanors. Maximum possible penalty is a $150 fine plus costs. The driving under suspension is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a no contest plea to the 3 charges? Can I have the facts?
On or about July 29th, 2026, in Hamilton County, state of Ohio, the defendant operated a motor vehicle with a driver's license that was under a child support suspension in violation of Ohio Revised Code 4510.111. On the same date and time in Hamilton County, State of Ohio, the defendant, while operating a motor vehicle, failed to maintain reasonable control of that vehicle, resulting in a crash in violation of Ohio Revised Code 4511.202. On the same date and time in Hamilton County, State of Ohio, the defendant also operated an unsafe motor vehicle in violation of Ohio Revised Code 4513.02. Insurance was marked no.
Finding of guilty, mitigation.
Both parties were insured, so he was driving a bad employer's bad truck. He has a good job. As far as the child support suspension go, he has his certified checks or cashier's checks sitting on his desk, ready to go, to take care of all of those and get his license straight. It's actually the only thing that's wrong with his license. I looked it up. So he should be good to go, and he just needs to get back on the hands. And to do that, I think that he can actually show his own insurance, and hopefully his bad employer to show their insurance as well to prevent suspension from coming. He's done it.
Is there anything from the state, anything else?
Nothing was here.
One, credit one, remit the fines and costs. The other series is dismissed for plea. All right.
Where's the bond on that?
Plus the state.
It'll be 9-1.
So that's the plate number, and then that's the social attached to the plate.
Dimensions.
The last four is social,
Sure.
and not this one.
Oh, so it's something else.
It's Robert.
This is Obidala Quran.
All right. Ron. Waive probable cause.
Yeah, Your Honor, no, I'm gonna ask for proper causes.
Your Honor, on or about August 11th, 2026, in Hamilton County, State of Ohio, the defendant entered into Mount Healthy High School. On that day, he took cologne, candy, and pens valued at $180.
Does this say whether the school was open or locked or?
I don't believe school was in session, Your Honor. However, there is a notation in the report that he walked in through an unlocked door.
Does it note if that other people were in there and it was 1 p.m. Okay. My understanding is the sun was out, lots of people were in there.
So as to probable cause being demonstrated, the threshold is pretty low.
I understand.
So the actual allegations themselves very rarely meet the probable cause threshold. As to bond from the state,
Just asking for a stay away from the school.
OR plus stowaway.
Grand jury on that will be 9-1.
Riggs, Riggs.
And then they have a code of conduct later on.
This is the exact.
Who's the last felon?
Good morning. Give me one,
We'll wait, Powell, we'll ask for his raise. Would like to be heard as the bond.
give me 1 second. I'm looking at the co-defendants to see if there's a difference in allegation.
Judge Esteban, Ms. Riggs is 56 years old. She is a lifetime resident of Hamilton County. She attended Hughes High School, currently lives in Mount Washington. She repeats that she's been employed full-time for the last 6 months at the Wendy's there in Mount Washington. In fact, she needs to work tomorrow morning at 6 a.m. I show maybe one minor misdemeanor conviction for her 56 years. She's an ORS score of 1. It's a felony 4. Bond preferences defer to prosecutor. It appears as if through the 527 that the other individual that was charged admitted ownership of the vehicle in which everything was recovered. So in light of the fact that she has her dating history, it's non-violent, we would ask for supervisor or bond.
From the state,
We'll defer,
supervisor Stern.
how was that? Grand jury, and that will be 9-1.
9-1, okay.
There is a common place for her.
Stearns. Step out there next to your attorney in the center, pull attention to the judge.
Your Honor, we'll waive probable cause.
All right, ask about it.
Your Honor, as to bond, I would just note these are both retail thefts, I believe from Myers stores. One is from April of last year, one is from May of this year. Unfortunately, Mr. Stearns does have a holder of another felony matter. So we are asking the court for nominal bonds on these charges, maybe 500 to 10%.
From the state,
Asking for a stay away from all Myers stores.
$500 anyway, plus stay away from mine.
Grand jury, and that will be 827.
Stewart,
About $50. Stewart.
Ernest Stewart.
Well, the courtroom's right here. Attorney, pull attention to the judge.
Small custom for Mr. Stewart at both his felony and misdemeanor cases, Your Honor. We have probable cause.
All right, ask about it.
Mr. Bond, this is a non-violent crime, Your Honor. Mr. Stewart also has some old charges from 1986 that at this point he doesn't even remember what they are for. He has 0 failure to appear in the last 5 years. He's assured me that if he had known about those charges in '86, he would have taken care of them. He's a veteran in veterans disabilities. He's provided me with a good address and good contact information. I don't think that he's a risk for not making it to court if the court were to not pay attention to the traffic charges from 1986. We're asking for nominal bond or SOR plus EMU in this matter. Well, these matters resolve themselves.
From the state,
Your Honor, I would be asking for a stay away from West Banco as well as the prosecuting witness. In this case, he did have a driver's license that was belonging to another person, as well as trying to cash a check or withdraw money from another person's bank account in the amount of $7,000.
ORMD on all of the new charges. The 86 case is actually a probation violation on the DUI. So it's not a new case. OR on that one.
Grand jury will be 8/27.
We can recall Antoine Moore.
I do have that case, Your Honor.
Oh, you have a copy of the one?
I do. This was, I highlighted some of the stuff that I knew I had read it, but it doesn't happen very often.
It's 8/27 for the last one. Thank you.
Or? You got, still got more
And you're gonna do everything?
on that last one, or, yeah. Except for the 86 probation.
86.
And obviously, this is a hearing to hold, Your Honor, but we do believe that could be relevant to the bond and overall this particular case. So we're asking for a lower and OR bond is what we're asking for given the circumstances. And I don't know if the facts came back that my client was not the owner of the vehicle.
It did.
Okay.
It was rented, belonged to a Robert Bertrand Lane, who's the registered owner of the vehicle. Just for a clear record, basically the summary of the first district case, which is Inicio Smith, says that this court, which is the first district, has yet to take the position that a driver is responsible for all contraband contained with the car, and rightfully so. To do so will create the problematic proposition that any driver, even if they are borrowing a car, would be strictly liable for all contraband found in the car. We decline to do so. And while those are all factual findings, and as the case progresses or does not, as far as the bond setting and what the allegations that have been presented thus far to this court is that the defendant was operating a vehicle that wasn't his. And does this say where the guns were found, or guns found in the car?
They were found under the driver's seat where he was seated. And the firearm was loaded with a round in the chamber.
Found to be ORMD.
This one? Grand jury will be 8/22. Out to the hallway, or yeah.
Tatum, Hardick. She wants to know. Do you want to put that in the jacket? That's yes.
Thank you.
Darren Nye for Ms. Tatum, Your Honor.
Good morning. Waive probable cause.
I'll note my client's 67 years old. This is a nonviolent offense, Your Honor. She's alleged to have taken 2 suits from Nordstrom's. I don't have her, at least on my paperwork, have any failures to appear in the last 5 years. She's got an OR score of 2. Apparently, she does reside in Missouri. She signed extradition paperwork to come back here. She's got 3 children, 5 grandchildren she actually takes care of. So we're asking the court to consider that in setting a bond, Your Honor.
From the state,
Asking for a stay away from Nordstrom.
supervised OR plus stay away from Nordstrom stores.
Grand jury, and that will be 9-1.
Terrell,
You're gonna go back with her.
you say hi, Mom.
That was your right on that door right there, and then you're gonna put you through a different door and let you out, and you're gonna get out.
Step out to the hallway. That's all. Terrell. Step out there, Mr. Attorney, full attention to the judge.
I will waive probable cause, would like to be heard as to bond for Mr. Terrell.
All right, as to bond.
As to bond, Your Honor, he is 22 years old. He is a graduate of Woodward High School. He's lived here in Hamilton County all of his life. Currently resides downtown here on Main Street with his mother, and he shares custody where he's actually the residential parent of his daughter, who's actually turning 3 in about 3 days. I have contact for him. I've got a telephone number for him. I've got a telephone number for his mother, and I've also got another telephone number for his girlfriend. So I have 3 ways to get a hold of him. He indicates that he's employed at Restaurant Depot, where he actually has his forklift license, and he's a forklift driver. He's been employed there for the last 2 years. I don't show any history of violence. If he is indicted on this, he's going to come to drug court. We have discussed that, and he actually would be willing and would want to participate. So in light of that, we would just ask for a supervised OR bond. It's a felony 5, and the allegations of marijuana.
As to the misdemeanors.
As to the misdemeanors, Your Honor, I haven't been able to get in touch with Judge Bender's court yet, but Mr. Terrell indicated to me that the last time that he was there,
Judge Bender?
I think it was Judge Bender.
I have Judge Mallory.
Okay, Judge Mallory, I'm sorry. Judge indicated, Mr. Terrell tells me that the judge indicated to him that he needed to get his temps. A lot of these charges are driving without a license. Mr. Terrell tells me that he has his temps, but they are in his property right now. So we're not able to get a hold of that to obtain his temps. We're asking, in light of Mr. Terrell's financial situation and the amount of work that he has to do, if the judge would consider reducing the bonds on these cases so that he can get out, obtain his property. As counsel said, we have contact information for him. We'd like to go ahead and get these matters set in front of the judge so that he can demonstrate that he's got his temps and moving towards getting his driver's license.
From the state.
We'll defer on the trafficking.
Judge, he's not coming to court on his traffic charges. The only reason he's here, he's got an felony.
So there are 10 failures to appear. I do not change other judges' bonds. What I will do is put the bonds back to what Judge Mallory set them at, as opposed to what the magistrate set them at after he was recited and did not show up again. So on the case ending in 9540, it's the same bond as Judge Mallory, which was $1,000. Anyway, on the 4341A, same bond, which was 1,000 anyway. On the B, same bond, which is OR from Judge Mallory's bonds. On the C, OR. On 29267, 1,000 anyway. On 22630, 1,000 anyway. On 19212, 1,000 anyway. On the new case, do you want a nominal bond with those other ones?
No, Judge, I still would ask for Supervisor Warren.
On that one, it'll be OREMD. Vega,
Grand jury report on that will be 827.
Vega.
Please probably cause, Your Honor.
Weigh probable cause
Yes, Your Honor.
as to bond.
Mr. Bond, Mr. Vega is 51 years old. He is a U.S. citizen, born in Los Angeles, California. He's lived in Cincinnati for at least a couple of decades, is what he tells me. He was driving someone else's car, but he gave permission to the police officers to search the vehicle, believing that there was nothing there because Mr. Vega doesn't do those types of narcotics that were found, or allegedly found in the vehicle. Yes, he's very concerned for his dogs that are currently at the SPCA. He's reiterated this like multiple times. He's hoping for a nominal bond. Right now, he knows that he can make anywhere from $100 to $300 bond. If the court would consider that, or an OR plus EMU.
From the state.
Your Honor, we'll defer.
On there's 6 failures to appear on the drug paraphernalia and the F5 drug abuse, OREMD, on all of the traffic, straight OR.
Grand jury will be 827.
Wind hold,
Alderson. All the way up to 22, OREMD. Weinhold.
Are you doing 827 on everything?
On everything except for the 2025.
Okay.
Darren Knight for Mr. Wenthold, Your Honor.
weigh probable.
We do, Your
cause.
Honor. I know my client is 24 years old. He's got 2 children with the alleged victim, or score of 1, no failures to appear, no felonies. He went to Elder and then to Great Oaks. He basically works at building crates at Trans. Can't read my own handwriting. Transpac. He tells me there was no fight there. That never happened. His the mother of his children called him to come over. That he'd been with her recently, 10 hours before. He contacted, when he found out he had a warrant, he contacted his uncle at District 3, spoke to him, and they refused him twice. He basically came, spoke to the officer, and we want to address the restraining order because the 2 children are listed on there. We don't believe they need to be listed on there, Your Honor. He gets his children Friday through Monday, he picks them up at daycare and returns them to daycare, and has no contact with the mother of his children. So he doesn't have a problem signing the restraining order or the stay away order. He just does not want his children on it, Your Honor. He tells me he turned himself into the District 3. They let him go. And then his uncle, he spoke to his uncle again. He said, you need to turn yourself back in again. And he turned himself in, Your Honor, and they finally kept him and brought him down. So for whatever reason, they didn't keep him in District 3. But we're asking the court to take that into consideration. He tells me he didn't kick in the door. That's what we've got, Your Honor. Well, it depends if they take the children off.
From the state.
Your Honor, based on my reading of the facts, it looks like the children were present when this happened. The victim had returned to her apartment with her two children. The defendant pulled up to the apartment building in a vehicle, and when the victim entered her apartment, he came right behind her and kicked in the door. Because of that, I would object to the children being removed from the protection order. I would also be asking for a monetary bond in this case and a stay away from the prosecuting witness. However, I know there is a protection order that I would ask to be executed.
Not going to remove the kids right now, since the allegations. Where does it have that the kids, is it in the affidavit?
It was in the arrest report that I got from an officer.
Since the allegations are that the kids were there at the time that a door was kicked in and that there's a physical altercation. So I would not take them off. So is he executing or no?
You want to execute that? Stay away. Who's willing to do that, Your Honor? Obviously, wants to be able to regularly see his children, but that's where we're at.
All right. There is one violent misdemeanor, 0 prior failures to appear. The misdemeanor looks like there was a strangulation that was amended to an assault. Is there anything else as to bond from the state?
Very
$10,000 anyway, plus juris if requested.
It will be 827.
Stephen Young.
This is the co-defendant from the.
What was the date again?
827.
You said 827. Thank you, Your Honor.
Thank you.
Thank you.
Your Honor, this is the co-defendant from earlier.
Thank you.
Yep, back one day. Young.
Wait, probable cause.
Your attorney, will listen to the judge.
Probable cause is waived. As to bond.
Mr. Bond, Your Honor, Mr. Young is self-employed as a janitor, commercial janitorial business. He only has 2 failures to appear over the last 5 years. He's got no holders. As I was talking with Mr. Young, should this proceed past indictment, He's looking to like drastically change his life and wants to explore whether or not he's eligible for the drug court. I've got good contact information for Mr. Young. He's got one child that's not residential with him, but that he provides a lot of support for. Oh, he lives with him, sorry. His child does live with him. Forgive me for that. We're asking the court for nominal bond today.
From the state.
Your Honor, this is the co-defendant of Ms. Riggs, who was in here previously. The defendant in this case admitted that the vehicle in which the drugs were found was his car. They did find approximately 5 to 8 grams of crack cocaine and marijuana, as well as approximately $1,000 in U.S. currency. I would be asking for a monetary bond in this case.
There is 1 violent felony, 10 misdemeanors, 2 failures to appear on the A and B, which are marijuana, OR, E, and B, on the F5. Crack cocaine, on the trafficking, 10,000 anyway, on the possession, 5,000 anyway, plus EMD. And then I have a warrant, will do county lockups next.
What's the grand jury date? Grand jury date
Oh, sorry, 8/27
on everything?
on the 4 felonies.
Okay.
There's only one case left.
Yeah, give me one second.
1039 with
Okay.
James Meyer. He's got a private attorney. I keep reaching out with Damon Davis.
Okay, I think she got some on the earlier. Is that the one from earlier? Okay,
So if nobody appears, it's just not guilty hours.
okay. That's the one for Damon Davis.
All right, we're ready on bacon or Bakken?
Or 2 of them.
Are you all taking care of these? Yes, these traffic.
Was hoping to talk to the county.
All right. Good morning. All right.
Your Honor, it's my understanding the defendant will be pleading to the 26 series, A and B, it's driving under suspension, 4510-111, unclassified, and failure to reinstate license, and also pleading to the 2025 series, the driving under Arraignment suspension, and driving under suspension, and then dismissing the remaining charges for plea.
I'm sorry, she's pleading to the 25A.
The 25A and B.
And the B is remaining the misdemeanor of the first degree.
It should be, it's a violator compact.
So I am not going to take a plea on these. I will send this because I would not do a one credit one. I would do what I would do in my courtroom, which would be a period of probation to monitor. There are, I think I just counted up 12 convictions, which do not even count with the 7 that are pending right now that are driving unders. And that also does not count the ones that have been dismissed for plea for the 12 other convictions. So it has gotten to the level that it's a misdemeanor of the first degree with basically 19 charges and 10 failures to appear. So, we can talk bond, or if you want to talk to Ms. Backen about a period of probation, which she could go to jail for up to 180 days if she gets caught driving again.
We can recall and let the talk with Ms. Backen, Your Honor.
Actually, let's just, if you would make a bond argument.
Okay. Your Honor, Ms. Backen's 37 years old. She has, she lives with her father. She has 2 teenage children at home. She's a longtime resident of here in Cincinnati. She acknowledges all of her failures to appear. She can't argue against that, but she's hoping that she can have a reasonable bond that she can make today so that she can go home to her kids, have good contact information, have a good address. And we can then start addressing all of these behaviors that she's been convicted of and accused of. Seems to be a pattern here that she'd like to try to address.
From the state.
Your Honor, just based on her history, I would be asking for a monetary bond or EMU to make sure that she comes back.
Right now, each of these are capious bonds that are set at 10,000 each. So 70,000 total right now. I will modify them to more reasonable bonds. On the 25 case, the A is an unclassified. The bond is $250 anyway, plus EMD. The B is a misdemeanor of the first degree, bond $1,000 anyway, plus EMD. On the 24 case ending in 4312, the is an unclassified, bond $250 anyway, plus EMD. The B, same, $250 anyway, plus EMD. On the 24-11029, unclassified, $250 anyway, plus EMD. And then same on the 26 series, $250 anyway, plus EMD. So it went from 70,000 to about 1,200 or 2,200.
There's a common police order.
All right. Bryce.
Price.
What? You are working this out. This one is an unclassified.
Okay, so Judge, I'll just wait for your time. Your Honor, it's my understanding Mr. Bryce is gonna plead to the A charge in exchange for dismissal of the B charge.
Mr. Bryce, a guilty plea is a complete admission of guilt. The driving without a license is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing the right to trial, the maximum possible penalties, do you want to maintain a guilty plea to 1 count of driving under suspension?
Can I ask some questions?
Yes. Counselor, do you waive and stipulate?
Wait and stipulate, Your Honor.
Finding of guilty. Mitigation. He's been here one night.
He's been in one night, Your Honor.
Is there anything from the state?
No, Your Honor.
1, credit 1, remit the fines and costs. All right, Clark.
Clark. Action about that, full attention to the judge.
Oh, look at
You want to enter a guilty plea then, Ms. DC?
Yes, sir. Yes, sir.
As charged.
Yes. Yes.
Mr. Clark, a guilty plea is a complete admission of guilt. This is a misdemeanor of the 4th degree. Maximum possible penalty is up to 30 days in jail, up to a $250 fine plus cost, and a possible period of probation. You have the right to a trial to the court, to a jury trial, to have your attorney call and cross-examine witnesses, to testify or not testify, and not testifying will not be used against you. If you are not a citizen of the United States, you are hereby advised that a conviction of the offense to which you are pleading guilty could have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. As in before you enter into the plea, this is not a case where I would do a 1 credit 1 unless there is some very, very convincing mitigation. Because it looks like Mr. Clark is currently residing in a sober living facility, picked up a substance-related charge, and defecated and urinated at Hard Rock. So there is definitely going to be a stay away, and then addressing substance use. So knowing that this is not just going to be a 1 credit 1 walk away, do you want to maintain the plea, or do you want to change the plea and have it go through the regular cycle?
We don't want to go into a plea, Your Honor. We'll go through the regular process.
As to bond.
As to bond, as you noted, Mr. Clark resides at a sober living facility. He's 55 years old. He's a maintenance tech at Cost USA. Funds are limited. He does not make a lot of money. He's a graduate of Norwood High School. He has lots of family in the area. He's provided me with phone number. And of course, I've got his address of where to find him. We'd like to come back and address this through the normal process. We're asking for reasonable bond or an alternate EMD.
Is there anything from the city?
We'd like him to stay away from,
Hard Rock.
yeah, the Hard Rock. Away from Hard Rock, please.
500 anyway, which is the standard bond. There's 2 violent felonies, 1 felony, 3 violent misdemeanors, 9 misdemeanors. $500 anyway plus a TAD unit plus no alcohol is a condition of bond. The TAD unit monitors whether you consume any alcohol, plus stay away from Hard Rock Casino. Craddock, there's a coming to this order.
Go back across the table. Craddock. Step up and next to your attorney. Full attention to the judge.
Michael Lancelotto for Mr. Craddock, Your Honor. Not guilty, Your Honor.
All right. As to bond, it looks like these are bonds that his trial judge set.
Yes, Your Honor. We submit on bonds. He's serving time, actually, penitentiary time at this time. So any monetary bond is agreed.
Is there anything from the state?
We'll defer.
It'll be the same bond that Judge Mallory, it was 1,000 anyway on each count that Judge Mallory said.
Yes, Your Honor.
All right, thank you. Duncan?
Duncan?
Yes. Michael Lancelotto for Ms. Duncan.
As to bond.
As to bond, Your Honor, Ms. Duncan has her GED, pardon me. She has some college. She has a 17-year-old child at home that she's the sole source of financial support and hands-on care. She's lived at her residence for over 3.5 years. She is not at any risk to the community, Your Honor. This was not a violent incident. I would ask for a
From the state.
Your Honor, I would be asking for a stay away from UDF on Montgomery Road.
That's agreed, Your Honor.
OR plus stay away from UDF plus defendant will be put in pre-trial random urine screens. Hodges.
Thank you. Yes.
All right, Lynn. Yeah. Miss Hodges, Lynn Hodges. Hodges, right? Are you Lynn?
Officer, Gregory?
Michael Lancelotto for Ms. Hodges. Please not guilty.
As to bond.
Your Honor, this is a very unusual case. Ms. Hodges is 62 years old. She has a bachelor's degree from the University of Cincinnati. Her only contact with the court was an OBI, more than 10 years ago. The circumstances are such that she's actually the complaining witness's landlord and mother of one of the individuals. She had guardianship over the minor children of the complaining witnesses through an order from Hamilton County Juvenile Court. The situation arose where she had to get a temporary restraining order against one of the individuals, and this was clearly retaliatory. She needs to get back to her home. She does not need to be held at this time, Your Honor.
Is there any note on what the alleged violation is? It just said did knowingly violate the orders.
We have
Call,
nothing more than
text.
That's all I
Okay.
have. I only have the complete and affidavit, and then the 527, the arrest report also says the exact same thing, so I don't have much information.
There's one misdemeanor, nothing else, 0 failures to appear, OR plus stay away.
Yes, Your Honor.
Hunter,
OR for Miss Hunter.
Not guilty, Your Honor. Esteban, Your Honor. Ms. Hunter has been, resided at her current residence for over 8 years. She has a 1-year-old child at home. She does hair in her home to support herself and her child. She has her GED. She's a lifetime resident of Hamilton County. She has minimum contact with the court. She does have one failure to appear within the past 5 years. She cannot recall what that was for. She assures me that she will attend any hearings scheduled in her case. We ask for OR bond, Your Honor.
from the state.
Your Honor, the allegations in this case are that the defendant punched the victim in the face while the victim was walking away with her son in her arms. I would be asking for a stay away from the prosecuting witness in this case. And based on the son being in her arms, I would ask for a monetary bond.
Your Honor, as you can imagine, doing braids and beads in her home, she does not have any cash to post a monetary bond.
It'll be 500 anyway, plus juris if requested.
Thank you, Your Honor.
Jackson,
Your Honor, Ms. Jackson was not in a condition to be present in court this morning. They are moving it to tomorrow.
continue 8/19 at 9. Lawson,
This law.
Michael Lancelota for Ms. Jackson, Your Honor.
does she have somewhere to go on EMD?
She does, Your Honor.
All right, is there anything from the state?
Your Honor, I would just be asking for a stay away from Tri-County beverage.
All right, there are 5 prior failures to appear. The bond of the OR plus EMD with a stay away from, what is it, Tri-State Beverage.
Thank you, Your Honor.
Richard, I'm 10 minutes explaining the details tomorrow. Left hallway, door plus EM.
Moats,
Raymond.
Please not guilty, Your Honor.
All right. Good morning, Mr. Notes. As to bond,
Esteban, Your Honor, you'll make note of the substantial record. Mr. Motz is 51 years old. He's homeless, but he has family in the community that he can stay with. He indicates that he can reside with his nephew. He's a high school graduate. He has a job cleaning a business establishment. He needs to get back to his job. He has no cash with which to make a monetary bond, Your Honor. He would ask for an OR bond.
from the state.
Your Honor, I was asking for a monetary bond in this case just based on Mr. Moat's record. I have a 63-page draft sheet in front of me. I will also note Mr. Moats is in room A almost every time that I'm in room A. So I do have concerns with him coming back to court and with continued behavior. I would also be asking for a stay away from BP gas station.
The best that I will do is to keep a standard bond on. There are 113 misdemeanors and 17 failures to appear. So the theft is 1,000 anyway, the trespass and the disorderly conduct are 500 anyway, which are the standard bonds. All right, and
Yes,
give
ma'am.
me a second.
Quarters in recess.
That's not it.
No, where do you think you going?
I'm just using it.
Oh, okay.
May I?
You gotta be there just as long as us.
Mr. Trapp. Mr. Middendorf, how are you today? Okay.
I got, I was just going to, no contest to your traffic charges. County's gonna drop, that one.
Can't stop you from Why do you want to do a contest?
There's a crash, I looked up the crash report and it's, just him. He basically got into it says it on the crash report here. He suffered a medical emergency for crash.
So this is a driving without a license, reasonable control, and driving under suspension.
Yeah.
You want 21, 21, and 24. You want to plead guilty?
Yeah, I think so. Could we?
Okay.
We're just gonna put in no contest on those.
You're gonna make-
We're making you read, I'm sorry to tell you. I'll wait and stick to it. Don't worry.
He's on the sheet.
Oh, in, so, are you on the Indian or anything? So you're out of line, so long story short, the felony strangulation got involved in that, but it still has a pending. And so the felony on, so you told me that it was.
It's different, but always the same.
So, correct, can I get where they were? Everyone else still working on 9, 9 o'clock? We're still waiting on 9, we're still going. 9. For those who are, you're got sided committee, you're paid bond, or those. Whatever makes it easy.
All right, Payne,
Mr. Payne. Go right in the middle next to your attorney, the Metro Area School Pension, and you face the judge.
Marquila Johnson, present. All right,
Judge, plea is not guilty.
Esteban.
As to bond, I have good in contact information from Mr. Raines, his mother, and a good place to stay away from PW. He only has 2 failures to appear. Highest charge on his record is a non-violent F5. He's lived in Cincinnati his entire, I'm
Hold
sorry.
on, who are we talking
about? I'm so sorry.
Okay.
I got myself Joshua Payne, excuse me. Yes, please still not guilty. He's executed the TPO.
He has much better facts than what you.
Yes, I know. We'll execute the TPO of Friedman as I was going along with this isn't right. Good number for Mr. Payne, good number for his wife. He has my card, a good place to stay away from PW. 0 failures to appear, 0 criminal convictions in adult, youth, or out of county. He turned himself in when he heard from his charges. He's been working 3rd shift in FedEx, needs to be back for work tomorrow. Graduate of Whitney Woods, stayed here his entire life. Judge, he's executed the TPO, 0 failures to appear, 0 records. He's going to come back to court and stay away while this is pending, asking for an OR.
From the state.
Your Honor, the allegations in this case are that the defendant threw apples at the victim's face, then proceeded to charge at her, grab her hair, and punch her in the face multiple times. Based on those allegations, I would ask for a monetary bond as well as the TPO to be executed.
Is this allegation, this is his sister?
I know it's a domestic violence relationship, I just don't have the exact relationship.
I have alleged victim, live-in sister. Does he have somewhere to live
Yes.
outside of his sister?
Yes, so we can say living outside of his
He's executing the protection order.
done and signed.
There's no record as an adult or juvenile, no failures to appear. OR plus the TPO. Rains.
Rain. Sir, y'all may go out right in the middle next year.
Leah Attorney here. Leah.
Cornell, can you see if the warrants are returned? They're returned? Okay, I'll do it in a minute. Those are quick.
Leah Stalling Attorney.
All right.
That one's for the last one.
Good morning, ma'am. What would you like to say?
I would not like to go forward with this case.
So once the charges are filed, it becomes the state's case and you the state's witness. But we can, I can consider what you have to say in reference to his bond. Are you concerned for yourself or any children? Do you want Mr. Raines to be ordered to stay away from you? Thank you, ma'am. All right. From the state,
Judge, the allegations are that Mr. Raines knowingly caused physical harm to Ms. Turner by punching her in the head with a closed fist, causing her pain following an argument. I don't have a record.
supervised OR based on what the PW came in and said today. Rashid,
You may go out and hang a left. Hunter, supervised. Right, you're turning it over.
Is she right here?
So as we've worked out these traffic matters, we entered a plea of no contest to 21 PRD 6699 A and B, and the 24 PRD 11880.
I'm sorry, you said 6699 A and B
Yes,
and 11880.
yes, both city cases.
And these are unclassified.
Yes, Judge.
And then the county are being dismissed.
The county 2022 series will be dismissed for plea, that's correct.
All right. Mr. Rashid, a guilty plea is a complete admission of guilt. The driving without, under suspension and without a license are unclassified misdemeanors. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. The failure to maintain reasonable control is a minor misdemeanor. Maximum possible penalty is up to $150 fine plus costs. You have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the 3 charges?
No contest.
Yes.
Was it no contest?
There's no contest, I'm sorry.
So, Mr. Rashid, a no contest plea is not an admission of guilt, but it is an admission of the facts alleged against you in the complainer ticket. All of the potential penalties are the same, it's just what the plea means is different, all right? You want to maintain a no contest plea? All right, can I have the facts?
Yes, Judge, on March 16th of 2026, it looks like, in Hamilton County, city of Cincinnati, Mr. Rashid operated a motor vehicle without a driver's license in violation of 4510.12 RC 4510.12, and also failed to control that motor vehicle in violation of 4511.22. There was an accident crash. Insurance was not shown.
What's the date?
There was what?
What was the date?
It's hard for me to read, Judge. It's like 3/16/2026. It's hard for me to read. Maybe it's
What
2020.
date do you have on the judge's sheet, Judge?
2020.
Maybe it's 2020. Zero, I'm not saying.
The case is a 21 case.
Okay. It's a 20. It's got to be that.
On the 24 case,
On that case, Judge, the defendant operated a motor vehicle in the city of Cincinnati, state of Hamilton County, without a driver's license in violation of 4510.101. Insurance was not shown. The date was April 20th of 24.
anything on the facts?
Nothing on that.
Finding of guilty, Mr. Rashid has been in one night.
Yes.
Is there anything else?
No.
1, credit 1, remit the fines and costs. Was there FRA on the 21 case? One, credit 1, remit the fines and costs. All right, as to the 19 case,
Yes, as to the 19 case, I do have good information for Mr. Shi and his mother. He has a good stable address. He's been trying to get SSI, but hasn't been able to connect yet. I've pointed over to legal aid to see if they couldn't help him out. The reason he's trying to get SSI is he was shot in the head a couple years ago, and that's part of the reason he's missed a lot of court. He's had medical issues dealing with that, had seizures. Actually, in part of the crash report, I was able to find the 24 case, if I can show you the it does say that he had a medical episode before the crash, but I think a lot of this is stemming from that. He's not had attorneys on him. I hope that I'll be able to facilitate getting him back to court, getting this worked out. He has about 28 days left on the shelf, so he's got motivation to get to court and do what he's got to do. Judge, we would ask to modify this bond to an SOR to allow for him to do so.
from the state, anything? supervised OR. Stamper,
Nope. So you're gonna hang at 11, you go see my partner? Yeah, you're my supervisor, Mr. Stamper. Come on out and see, yep, your attorney's right there, he's there, he's gonna turn it to the wall, it's talking about.
these are
Yes, sir.
all minor misdemeanors.
Yes, they're all parking violations, Your Honor. It's my understanding the defendant is going to be pleading to the case ending in 1367, and the remaining two will be dismissed quickly.
All right, Mr. Stamper, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus costs. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to, what is the charge? Parking, improper parking in a storage facility?
Yes, Your Honor, I believe the boat was parked
Front.
on the front lawn, so
Okay.
it was just a zoning.
Okay. Do you want to maintain a guilty plea to that violation, sir?
Yes, ma'am.
All right. Counselor, do you waive and stipulate?
Wait.
Finding of guilty. Mitigation.
Judge, he has figured out his boat, he's gonna remove it, gravel his backyard and put the boat back there. He just had turned himself in last night, got it, and they brought him down here, asking for credit for the night.
From the state.
Nothing from the state.
One, credit one, remit the fines and costs. Stevenson,
Judge, I was made aware that Mr. Stevenson was waived this morning.
Go this way, you have actually goes for an hour or so.
Bring it tomorrow. All right. Continue to 8:19 at 9. Williams.
Miss Williams, and bond setter, please. Right in the middle, next to your attorney, and meet you in the middle.
All right.
Please.
Does Ms. Williams have somewhere to go on EMD? Actually, that probably from the state, I'm worried about the alcohol piece, so it would be a tad, not an EMD. Is there anything from the state?
We would just be asking that no alcohol be a condition of one.
Did you want to make a different argument
No.
against that? It'll be OR plus no alcohol plus TAD. Katia Braswell.
Yep, go ahead, come in, you can smile now, that's right there, you go, smile, going off, okay?
And
They are.
did you pay the bond? Good morning, Ms. Braswell. Did you pay a bond?
I did, yes.
Check it out. All right. You know how much you paid?
I
Is it
believe
1,000?
2,500, so it's 250, so it's $75 fee.
What number OVI do you have?
This is the first ever.
ALS?
ALS is in place. There was a refusal. FRA marked no accident.
You said no accident.
No accident.
It'll be an OR bond. You need to stop there so you can get your paperwork processed.
That's it?
Yes, ma'am. Then, well, no, hold on. Go there first and then go to room 117.
Perfect.
All right, for your next court date, contact an attorney, and your license is suspended, so no driving until you get privileged. All right.